Hello, my name is Peter Brix. I'm a debtor bankruptcy attorney practicing in the Northern District of Georgia. I also have offices in Atlanta, Dunwoody, and Jonesboro. Today I'm going to talk to you about the Meeting of Creditors, also called the 341 meeting, also known as your trustee meeting date, your debtor's examination. Before I do, I want to let you know we are a debt relief agency proudly assisting consumers in filing bankruptcy. There is no attorney-client relationship with the viewer of this message unless we have an attorney-client relationship through a fee agreement. Then everything here is just intended for educational purposes. So today we're going to talk about 341 meetings, meeting of creditors. When you file, this is a requirement of the code, you have to attend this meeting. There's really no way around it. So in other words, when you file, you will be going to court. Depending on some districts you're in, you actually might not be in a court. You could even, I've seen them even in hotel rooms. But if you're at least in the Northern District of Georgia, you're in these metro Atlanta counties, you're going to be at the Atlanta courthouse at the Richard Russell Federal Building. You'll get notice of this court date within usually about 3 days after you file your case. The date will be about 5-6 weeks later. At that, what I like to do is I have a list of typical questions you're going to expect to receive. They're typical of every meeting, and I present them to my client before the meeting, and we discuss them. Additionally, the other things I remind them of, you have to have proof of your Social Security ID for this meeting. That is an original, that's either a card or a W-2. So really you should be, have that kind of thing ready when you're ready to file bankruptcy. I mean, really your attorney should get some proof of your Social Security number even before the case is filed. But you should have that, and then if you don't have that, you should go to your Social Security office, apply for a new card. They'll also give you some kind of confirmation because you need to prove who you are. If you can't, the trustee might still hold the meeting, but they'll ask you to come back at another date just to prove your Social Security ID. You also need to bring a picture ID. You will go through security at the beginning, and you need to prove who you are, so you have to have your picture ID. A good thing not to bring with you is your cell phone. If it's a camera phone, they're going to ask you to turn it in. Sometimes they might even ask you to just go back to your car and leave it there. So you don't really need to bring your paperwork per se. If you're my client, I'd ask you to take a look at it before the meeting. Remind yourself of some of the figures you listed, but you don't need to bring it with you. Your attorneys, either on their computer or their hard copy, would have your information. The questions you get are fairly there's a slew of questions that are going to be asked to all debtors. I actually ask my clients to come about 15-30 minutes early. Their trustee, unless they're like the first calendar of the day, will be already talking to someone in a previous calendar most likely, so they can sit there and get a feel for how the trustee asks questions, and then they also, I know this can be a nervous experience for debtors. Maybe they're less nervous by the time they've reviewed my list of questions and seen the trustee in action. Okay, so basically you get typical questions. You produce your Social Security ID and your driver's license immediately to the trustee. You get sworn in. They might ask, why did you file bankruptcy? They'll ask, did you read your information statement, which you probably read when you consulted with your attorney? Did you sign everything on your petition? They want to make sure you actually signed it yourself. Did you list all your assets, all your liabilities? You might have a home that you own, in which case they'll ask how you came to the value of your home. They'll ask you if you have some potential lawsuits, like do you get into a car wreck, do you have a potential personal injury suit, something like that. Additionally, they'll get into whether you have potential inheritances. You have to turn over inheritances or life insurance proceeds recovered even 180 days after you file the case. So the trustee will remind you of that. Then they'll get into some specifics of your case. You might, there's a thing called the Statement of Financial Affairs where you listed assets you transferred in the last couple of years. So if you have some, particularly if you transferred something of value, not like a short sale home, because that actually is a transfer, but if you transferred away something of value, did you get equivalent value for that? If you did not get equivalent value for that, then you've made a gift. So now we get into why, how much, who was it. It's not like, at that meeting the trustee is going to necessarily announce something critical, but the trustee might discover something that, oh, you gifted something away to a relative, and now they're going to want to be in contact with that relative after the meeting. But the typical meeting lasts about 5 minutes. So you could be on the 8:30 calendar, and you have a 5-minute meeting, and boom, you're the first one on the calendar. You could be at work not much later than 9 a.m. So it's not really something you have to devote your whole day. If you wind up at, say, a lunch hour calendar, then it might be a little inconvenient because now you've got to commute back and forth, and you really, for a 1 o'clock meeting, kind of have to be out from like 11:30 or 12 to 2:30. Sometimes calendars run behind, so you might be on a 2 o'clock calendar that doesn't get called till 2:45. But generally speaking, if you're on a 2 o'clock calendar, the latest you should be out of there is 3. Chapter 13, Meeting of Creditors, are a little bit more detailed, and that one they go into their objections because you're in the repayment plan, as far as whether you're coming up with a real fair repayment plan to all your creditors. But the questions are fairly similar. In that one, they might go into proof of claims, which creditors have filed claims, because you need to pay them according to your plan, and whatever amount your plan calls for. So that one's a little more detailed, but basically the questions are the same, and it's not actually in a courtroom. You're not in front of a judge. You're being questioned by your trustee. So in that sense, it might be a little less intimidating. But that pretty well sums up your meeting of creditors in Chapter 7, Chapter 13, bankruptcy.